viewers, welcome back to the Personal Injury Law Show. Before the break, we were talking about bullying, and now it's Kathy's Mailbag. Kathy, what did you think of that?
Good evening, viewers. Tony, John. Well, it was very interesting. Bullying is not condoned in any workplace, and I found it quite intriguing as well that this time tables were turned, because generally in the media recently in particular, we've been hearing about females being bullied, and it's not the case. It's males
It's
are
both
being.
sides.
That's right, and I think that this case actually shows that it's everyone, and we have to be careful with what we say and how we act, especially in a work environment.
What concerns me, Kathy and John, is that the incidence of bullying seems to have increased. There seems to be a lot of people making the inquiries. I just turn a lot of people away because they don't have corroboration of the evidence, John. They don't have the witnesses to back them up.
And not only that, it does have to be a significant incident, doesn't it?
That's right. And also the injuries have to be ongoing, long-term. Yes. So, generally, if you can get out of the workplace and find a different job, that's what we prefer, because, you don't want to be caught up in a system where you're taking medication, you're getting psychiatric treatment, psychological treatment.
Yeah.
You're better off to try and keep moving on with your life.
Well, it's not good for one's mental health as well.
No,
Sometimes we
no.
have to place ourselves out of the environment that's affecting us. But
That's exactly
I think it was a very good outcome for Mr. DiPietro, and it was a great victory for Carolyn as well.
That's
She put a lot
exactly
of work in. So,
And beware,
all the time.
the message.
All right, well, we have to move on to our questions as viewers have written in. So the first one is to the PI show, and it's from Cheryl in Endeavour Hills. I'm inquiring as to whether you would represent a 14-year-old boy who has been advised by his sports club that as a result of his parents lodging a complaint on his behalf regarding bullying and harassment he endured from his coaches, that the boy and his parents' association with the sports club is now untenable and are no longer wanted as members. Now, Tony, how can you answer this for Cheryl? What are your thoughts?
I would have thought that if he's got issues of a psychiatric nature, because I'm a bit confused about this question. I'm not sure whether they want to become members again. I don't really know what it means, but I'm assuming that they're talking about some sort of effect it's had on the child. And if that's the case, I would have thought that if you've got more than 10% whole person impairment under the Wrongs Act, because it doesn't say, it's not a work situation, John.
No.
It's public liability. In those circumstances, I think that you could probably suit a club.
It seems that way, Tony. A 14-year-old suffering this type of bullying is unacceptable.
Yeah.
And the club should be held accountable.
That's exactly right. But the thing is, it could have long-lasting effects on him, because it's at that development stage of his life. 14 years of age, he's got to get onto higher education and things like that. And if he becomes withdrawn and introverted, he might not perform well at school.
With a 14-year-old boy, his self-esteem has probably been
taken a nosedive.
Exactly.
Not just that, he's at the age he wants to play sport and be involved in the social network as well. So
that's exactly right.
And this issue about no longer wanted as members, Tony, that's difficult, isn't it?
Oh, look, I think that you could address that. There's means and ways. You'd probably get a lawyer to write a letter to say that it's a form of
discrimination.
Right. You'd probably take it to the Equal Opportunity Commission. Who knows? I mean, but at the end of the day, you'd think that if you've got enough people behind you,
well, in this
at the
day
club,
and age, it's not acceptable this time.
No.
I
think a letter would suffice here.
Yeah.
That's right, but I would say more facts need to be ascertained as well.
Yeah,
but we hope that's helped, Cheryl. Moving on.
Get legal advice.
Of course, as always, please seek legal advice. Moving on, we've got our second question. To Tony, John and Kathy. I was injured at work in 2006. As a result, I've had 2 back operations and have been on work cover ever since. I've currently returned to work on modified duties for 4 hours per week, 3 days per week. It's 4 hours per day, 3 days per week. I've had more bad days than good days and suffer from chronic pain. However, I've been told that work cover won't pay my wages anymore, though they will still cover medication, I believe. Hoping you can advise me, Vicky from Reservoir. Now, that's pretty bad, John. 2006 is the injury. Poor Vicky. I mean, she's had an operation or 2 operations on her back, and she's still suffering.
Yeah, she's still suffering. However, she's exhibiting a work capacity. It looks like it's only 12 hours a week, Tony.
Yeah, now look, if she can get up to 15,
then
under a provision of the legislation,
Section
she can
93
get 80% of her pre-injury loss of earnings paid
for
the hours that she can't work.
So if she can work at least 15 hours a week, then there can be...
She'll have rights.
Exactly. But at 12 hours, after 130 weeks, Kathy, you're not entitled to weekly payments.
But John, she's had 2 back operations, so I would have thought that if there's negligence in the way she got injured, she's probably got a common law claim.
You've got lump sum entitlements, including a permanent impairment benefit claim, which is a no-fault benefit for this injury, and also you then have a common law damages claim, and you've got a significant injury.
And John, the wording's pretty poor where she says suffer from chronic pain. She's had 2 operations for crying out loud.
Exactly, 2 back operations.
Yeah.
That's right.
Now,
So
that's
pretty devastating.
Prima facie, that is serious.
Very serious, significant in itself. Yeah.
So you do have entitlements, Vicky. However, you do need to seek legal advice there, particularly in regards to your lump sum claim, because you might find that is a better way to go. But Tony, I just wanted to ask one question.
Yep.
A lawyer playing golf at a golfing day, especially in regards to his left
I think I know that
elbow,
lawyer, John. It
does
was
he
a
have
very,
entitlements?
very trivial incident.
Does he have entitlements?
Get some deep heat on that.
Tony,
I would advise him to seek legal advice, John.
who do I see? That's the problem.
You need a bit of deep heat.
It's a lawyer's golfing day, and I've got
It was self-inflicted.
tennis. It's almost like tennis elbow.
Self-inflicted. You should have got some golfing lessons before you went out there.
That's called contributory negligence.
You should not have played.
I was required by my employer to play. Problem is, I'm the employer
Strong
also,
words coming
Tony,
from
aren't
John
I?
viewers. Strong
I think
words.
we've got to move on from this one.
We've actually got a very interesting question, Tony. This comes from Trudy in Endeavour Hills. Dear PI Show, I had recently became pregnant after a doctor incorrectly inserted my Implanon, which is a form of birth control that works by releasing hormones from a rod in your arm. I was wondering if I could claim any compensation. Tony, that's really interesting. I mean,
yes, this was in the papers recently, I think. The answer to that question is yes, you can claim compensation. It's sadly, and the child one day is going to know this, but it's a wrongful birth. And as the law currently stands, you can claim the cost of raising a child. So the answer is yes, get legal advice.
All right, we hope that's helped, Trudy. Viewers, please keep writing in, and our new email address is info@thepishow.com. We love answering your questions. Thank you very much. Have a lovely evening.
Thanks, John.
Thank
Thanks,
you.
Kathy.
Thanks, Tony.
Thanks, viewers.
Good
And
evening,
stay
viewers.
safe.